Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Hi everyone. I'm 23B1003. My name is Nurian Hana Takifa. And my friend is 23B0829. Her name is Isyan Izati. And we are gonna present a topic about Hukm of Al-Ijtihad according to traditional Muslim scholars. Our agenda has 5. Number 1, we have the introduction. Second, we have the modes of ijtihad. Next, we have the scope of ijtihad. And then we have the hukum of al-ijtihad. And last but not least, we have the conclusion.
As an intro, the Holy Book of Islam, Quran, is one of the main sources of Islamic law. The Quran contains laws that are expressed directly or indirectly. Due to the existence of indirect laws, Muslim jurists had to perform an ijtihad to comprehend and to apply the teachings of Quran into certain situation. So the word ijtihad comes from an Arabic verb jahada, which means effort. The literal meaning of ijtihad is the exertion of maximal effort and energy into performing an act. It is an act of putting much effort and the struggle in order to produce a single principle or hukum of Islamic law through interpretation. So basically, ijtihad is principles that are not precisely or directly stated in the legal text of Quran and Sunnah. So the final result of principle is taken from interpretation of Muslim jurists. Next, modes of ijtihad. Based on Imam Al-Ghazali, there are 3 ways that the principle of Islamic law has been discovered. The first one, principles stated clearly in the legal text. In this first mode, hukum are stated clearly in the text of Quran and Sunnah. Muslim scholars attempt to adhere as precisely as they can to the meaning of the text. For example, in Surah Al-Baqarah, ayah 275, where it means, but Allah has permitted trading and forbidden interest or riba. So in this verse, it has been clearly mentioned that any type of financial transaction are allowed in Islam except those bearing interest or riba. So hukums that are included in this mode must be followed as how it mentioned in the text of Quran and Sunnah, no matter how contradict it is to the purposes of law, because it has been declared clearly in the Quran and Sunnah. Second mode of ijtihad is principles derived from analogy of jurists. Any hukums that has been included in this mode is hukums that has been derived from legal text, Quran and Sunnah, through analogy or a process mostly known as qiyas. This mode is used to address any hukums that is left unclear. Muslim jurists made an attempt to apply any hukums that has been developed from the first mode of ijtihad to novel scenarios that has not been specifically mentioned the hukum of it in any legal text. So the steps to derive hukums in this mode is that first, the underlying meaning of a hukum is determined, and then next, the new case that the jurist has been facing would be examined. So if it carries similar meaning, the hukum is assigned to the new case. So the third and last mode of ijtihad is principles delivered by the jurist. This mode is used when the first 2 modes cannot be carried out. So in this mode, jurists had to conduct collective analysis of all legal texts. The legal reasoning of the text is more in accordance to its purpose its purposes of law rather than the meaning of the text itself. So in this mode, Muslim jurists had to put forward high effort in applying general hukum when the principle complies with Sharia purposes. Scope of Ijtihad. Most people has mistaken Ijtihad as a source of Islamic law. However, it is not. Ijtihad is a process and effort in deriving hukums from legal texts of Quran and Sunnah. It is the workings of Muslim jurists in deriving hukums from legal texts using the methods of interpretation. So Ijtihad is only allowed to be done in texts that has an unclear hukum. Ijtihad only focuses on unclear hukum in legal text, which gives different meaning according to each individual's interpretation. So jurists will conduct an analogy when hukum of the text cannot be understood directly. One of the requirements for jurists to perform ijtihad is they need to understand Arabic language. This condition is only applied for the first two modes of ijtihad, while some said that the third mode in deriving principles are allowed for anyone, even if one does not understand Arabic language. However, it is preferable that the person who performs ijtihad and deriving a law is from a well-qualified person, as the work carries a great deal of responsibility.
Now I'm gonna talk about the Hukm of Ijtihad. Hukm of Ijtihad is depending on the condition of mujtahid, in which mujtahid is a person who gets malakah, ability to deduce law from his arguments. In language, the word ijtihad means ability and difficulty. That means that the mujtahid are serious people and carry out cases to the peak of their seriousness to reach legal conclusion. It is necessary for a mujtahid to possess the necessary skills so that the process of legal finding is genuinely based on his understanding and ability. Three skills are often required for a mujtahid to deduce a law is that they have the ability to understand the Quran, the Sunnah, and Ijma. Second, the knowledge of a language. Third is expertise with usul fiqh. Scholars argue that in determining the law of ijtihad, if a Muslim is questioned or confronted regarding an incident or a matter pertaining to Sharia law, then the law belongs to those who are questioned or confronted, or either they are fardu ain, fardu kifayah, sunnah, or haram. Fardu ain, in order for someone to become fardu ain, an event must occur and they must fulfill the necessary requirements in order to execute the ijtihad. Another situation is when a mujtahid is being questioned about a situation that has happened. Ijtihad turns into fardu ain because they fear that if no one responds, this will convey an incorrect understanding. Fardu kifayah, an event occurs, but he is worried that there will be no certainty regarding the law, but they are still mujtahids. Otherwise, the law of ijtihad is fardu kifayah. Next is about sunnah. Sunnah when resolving legal conflicts. A mujtahid who meets the standard for ijtihad performs ijtihad sunnah. When something specific issues hasn't happened yet or hasn't happened at the moment and it hasn't been referred to the mujtahid. Therefore, in this case, a jurist is acting solely out of initiative when performing ijtihad. To sum up, the sunnah of ijtihad is when it is used to an issue that has not arisen. Haram, if ijtihad is performed in a way that goes against the current nas and dalala rulings, or deal with laws that have reached ijma, consensus. It is considered to be something for which ijtihad is no longer necessary. The conclusion from this discussion: the companion of the Messenger of God already practice ijtihad in all circumstances, but they do not have an organized basis of ijtihad. It can be concluded that the first fiqh and ijtihad in the history of Islamic jurisprudence came from the companions of the Prophet. This make ijtihad had a great impact on the development of fiqh in the future. Even though Rasulullah SAW also did ijtihad regarding the well-being of society as a whole, and performed ijtihad in accordance with the fundamental principles of Sharia. He did not need to wait for revelation from Allah Subhanahu wa Ta'ala. Ijtihad is not a source of law, but it is the process and the struggles of interpreting principles from legal texts, the Quran and Sunnah, done by Muslim scholars. Next is the hukum of performing ijtihad may vary in different cases. So that's all from our discussion. I hope everyone can understand what are we trying to convey and explain about the hukum of ijtihad. And thank you very much.